Namaskar. In today's case note, I shall be bringing to the notice of our learned audience with regard to the principle as reiterated by Honorable Supreme Court, namely crime and criminal test on the point of awarding capital punishment in the case of Veerendra versus State of Madhya Pradesh, criminal appeal number 5 and 6 of 2018, decided on 13th of May 2022. The judgment was pronounced by a three judges bench of Honorable Supreme Court. Now, briefly going to the facts of the case, on 10th of September 2014, the deceased, who was then 8 years of age, was stripped, raped, and strangled by her uncle accused. On 20th of September 2014, an FIR was registered at the police station, and on the same day, the accused was arrested. Upon conclusion of the trial, he was convicted on the basis of circumstantial evidence under Section 302, 376A and Section 376 subsection 2, subsection I of the IPC and Section 6 of the POCSO Act. Consequently, he was awarded death sentence on first two counts subject to the confirmation by the Honorable High Court, and life sentence under the third and fourth count, besides sentence of fine of rupees 2,000 each on all counts. All the substantive sentences were ordered to run concurrently, as ordered under the said judgment in respect of the sentence of capital punishment. Reference was made to the Honorable High Court of Madhya Pradesh. The appellant, that is the accused, also filed a criminal appeal challenging his conviction for the stated offences and consequential sentences imposed therefore. As per the common judgment, Honorable High Court partly allowed the appeal as well as the reference made to it. Honorable High Court also affirmed the death sentence but set aside the conviction and sentence of offence under Section 376A on technical reasons. On appeal preferred by the accused before Honorable Apex Court, Honorable Apex Court, after scrutinizing the entire evidence, did not find any perversity on the concurrent finding of the trial court. And an Honorable High Court that the appellant herein had committed offences punishable under Section 302 IPC, 376 subsection 2 I IPC and Section 6 of the POCSO Act. On the point of sentencing of the offences under Section 376 subsection 2 I IPC and under Section 6 POCSO Act, Honorable Apex Court did not find any extenuating circumstances warranting an interference with the sentence thus imposed by the trial court, which was confirmed by Honorable High Court. However, the question before Honorable Apex Court was whether death sentence awarded by the trial court and confirmed by Honorable High Court for the conviction of the offence of murder be maintained or substituted. In order to adjudicate upon that, Honorable Apex Court recapitulated three principles: crime test, criminal test, and rarest of the rare test. Now let us see what are these principles, how these principles were reiterated by Honorable Supreme Court and how they were applied in the given case, and what was the final outcome. For that, let me take you to the judgment itself. So for that, we have to go to page number 72. The next question is whether death sentence awarded by the trial court and confirmed by the High Court for the conviction of the offence of murder be maintained or substituted. This penalty is awarded to a culprit only the category of the case falls under rarest of rare cases. The culprit has become a threat to the society at large and beyond reformation, and his elimination is the only way for eradication of the threat. For deciding the said question, various aspects have to be considered. On a careful scanning of the consideration made by the trial court as also the High Court for awarding the sentence for the conviction under Section 300 IPC, punishable under Section 302 IPC, we are of the view that the question regarding the Correctness of the death sentence awarded to the appellant requires further consideration, taking into account the statutory requirements under Section 354, subsection 3 CRPC. For awarding termination of natural life, a careful scrutiny is required. The statutory requirements under Section 354, subsection 3 CRPC are as under. Quote, when the conviction for an offense punishable with death or in the alternative with imprisonment for life or imprisonment for a term of years, the judgment shall state the reasons for the sentence awarded, and in the case of sentence of death, the special reasons for such offense. Unquote. In pad number 53, it was observed that on the aforesaid subject, this court has already enunciated the principles. A careful survey of such decisions was made by this very three-judge bench in the decision in Pappu versus the state of Uttar Pradesh pronounced on 9th of February 2022. Paragraph 49 of the decision in Shankar Kishan Rao Khade versus state of Maharashtra reported in 2013, Volume 5, Supreme Court Cases 546, highlighting the requirement of application of crime test, criminal test, and rearrest of the rear test was referred therein. In the said paragraph, with reference to the previous decisions, the aggravating circumstances, crime test, and the mitigating circumstances, criminal test, were narrated as under. Quote, in Bachchan Singh and Machi Singh cases, this court laid down various principles for awarding sentence. Aggravating circumstance, that is crime test. First, the offenses relating to the commission of heinous crimes like murder, rape, armed dacoity, kidnapping, etc. by the accused with a prior record of conviction for capital felony or offenses committed by the person having a substantial history of serious assaults and criminal convictions. The offense was committed while the offender was engaged in the commission of another serious offense. Third, the offense was committed with the intention to create a fear psychosis in the public at large and was committed in a public place by a weapon or device which clearly would be hazardous to the life of more than one person. Fourth, the offense of murder was committed for ransom or like offenses to receive money or monetary benefits. Fifth, hired killings. Sixth, the offense was committed outrageously for want only while involving inhuman treatment and torture to the victim. Seventh, the offense was committed by a person while in lawful custody. Eighth, the murder or the offense was committed to prevent a person lawfully carrying out his duty like arrest or custody in a police of lawful confinement of himself or another. For instance, 90 murder is of the person who had acted in lawful discharge of his duty under section 43 of the Code of Criminal Procedure. Ninth, when the crime is enormous in proportion, like making an attempt of murder of the entire family or members of a particular community. 10th, when the victim is innocent, helpless, or a person relies upon the trust of relationship and social norms like a child, helpless woman, a daughter, or a niece staying with the father or uncle and is inflicted with the crime by such a trusted person. 11, when the murder is committed for the motive which evidences total depravity and meanness. 12th, when there is a cold-blooded murder without provocation. 13, the crime is committed so brutally that it pricks or shocks not only the judicial conscience, but even the conscience of the society. Now, talking about the mitigating circumstances, the criminal test. Point number 1, the manner and circumstances in and under which the offense was committed. For example, extreme mental or emotional disturbance or extreme provocation in contradistinction to all these situations in normal course. Number 2, the age of the accused is a relevant consideration but not a determinative factor by itself. Number 3, the chances of the accused of not indulging in commission of the crime again and the probability of the accused being reformed and rehabilitated. Number 4, the condition of the accused shows that he was mentally defective and the defect impaired his capacity to appreciate the circumstances of his criminal conduct. Number 5, the circumstances which in normal course of life would render such behavior possible and could have the effect of giving rise to mental imbalance in that given situation, like persistent harassment, or in fact leading to such a peak of human behavior that in the facts and circumstances of the case, the accused believed that he was morally justified in committing the offense. Number 6, when the court upon proper appreciation of evidence, is of the view that the crime was not committed in a preordained manner and that the death resulted in the course of commission of another crime and that there was a possibility of it being construed as consequences to the commission of the primary crime. 7. Where it is absolutely unsafe to rely upon the testimony of a sole eyewitness, though the prosecution has brought home the guilt of the accused. This court further said, aggravating circumstances, as pointed out above, of course, are not exhaustive, so also the mitigating circumstances. In my considered view, the tests that we have to apply while awarding death sentence are crime test, criminal test, and the RR test. That is rarest of the rare, and not the balancing test. To award death sentence, the crime test has to be actually satisfied, that is 100%, and criminal test 0%, that is no mitigating circumstance favoring the accused. If there is any circumstance favoring the accused, like lack of intention to commit the crime, possibility of reformation, young age of the accused, not a menace to the society, no previous track record, etc., the criminal test may favor the accused to avoid the capital punishment. Even if both the tests are satisfied, that is the aggravating circumstances to the fullest extent and no mitigating circumstances favoring the accused, still we have to apply finally the rarest of the rare test. RR test depends upon the perception of the society, that is society centric and not judge centric. That is whether the society will approve the awarding of death sentence to certain types of crime or not. While applying that test, the court has to look into the variety of factors like society's abhorrence, extreme indignation, and antipathy to certain types of crimes like sexual assault and murder of intellectually challenged minor girls, suffering from physical disability, old and infirm women with those disabilities, etc. Examples are only illustrative and not exhaustive. The courts award death sentence since situation demands so, due to constitutional compulsion reflected by the will of the people and not the will of the judges. Unquote. In para number 54, it was observed that after taking into account the same and such other decisions specifically referred to therein, in Pappu's case, it was held, thus, quote, it could readily be seen that while this court has found it justified to have capital punishment on the statute to serve as deterrent as also in due response to the society's call for appropriate punishment in appropriate cases, but at the same time, the principles of penology have evolved to balance the other obligation of the society, that is of preserving the human life, be it of accused, unless termination thereof is inevitable and is to serve the other societal causes and collective conscience of the society. This has led to the evolution of rarest of rare test and then its appropriate operation with reference to crime test and criminal test. The delicate balance expected of the judicial process has also led to another midway approach in curtailing the rights of remission or premature release while awarding imprisonment for life, particularly when dealing with crimes of heinous nature like the present one. Unquote. On going through the judgment of the trial court and the high court in para number 55, it was observed by Honorable Supreme Court that we are of the considered view that in handing down the capital sentence, what had weighed with the courts are the horrendous feature of the commission of the crime and the hapless state of the victim. The trial court considered the question of sentence and awarded the same on the very same day on which the appellant was convicted. We shall not be understood to have held that this is absolutely illegal and impermissible. Ultimately, what is required is consideration of the aggravating and mitigating circumstances with the application of mind. They were not given the proper attention while considering the question of awarding the sentence for conviction under section 302 IPC in the case in hand. In the said circumstances, now we will proceed to consider the question of sentence in the present case, bearing in mind the principles enunciated by this court in the matter of awarding the capital sentence. The trial court as also the High Court arrived at the conclusion that the act of the appellant invited the extreme indignation of the community and therefore it deserves a deterrent sentence so as to give a message to the society that such crimes should not be repeated by anyone. In short, we are of the considered view that the crime test and the criminal test required to be followed before awarding capital sentence did not gather the required attention of the trial court as also the High Court. It was observed in par number 56 that it is true that all murders are inhuman. For imposing capital sentence, the crime must be uncommon in nature, where even after taking into account the mitigating circumstances, the court must be of the opinion that the sentence of imprisonment for life is inadequate and there is no alternative but to impose death sentence. The heinous and brutal nature of the commission of crime, with brutal rape and murder of an 8-year-old girl child who is none other than the daughter of his own cousin, that too in a hapless situation, is definitely an aggravating circumstance. The nature of the injuries caused on the private parts of the victim, as is evident from the evidence of PW10 with Exhibit P17 report, would definitely shock the conscience. At the same time, the principles enunciated by this court in the matter of awarding death sentence and in such circumstances, the undisputed and indisputable fact that the appellant had no criminal antecedents of and he hails from a poor socio-economic background and also his unblemished conduct inside the jail cannot go unnoticed. So also it is a fact that at the time of commission of the offense, the appellant was aged 25 years. Hence, viewing the issues taking into account the aforesaid aspects, we do not find any reason to rule out the possibility and the probability of the reformation and rehabilitation of the appellant. The long and short of the discussion is that the present case cannot be considered as one falling in the category of rarest of rare cases in which there is no alternative but to impose death sentence. In par number 57, it was observed that in the aforesaid circumstances, the next question is what is the comeuppance for the conviction for offense of murder in this case? In the decision in Swami Shraddhananda versus State of Karnataka, taking into account the tenets of penology and with a view to have a just, reasonable, and proper course in a case where the court is of the view that the sentence for life is inadequate but imposition of death sentence is unwarranted, this court adopted the course of awarding life imprisonment without application of the provisions of premature release or remission before an actual imprisonment for a definite period of time. This position was iterated with the agreement in the decision in Union of India versus Sriharan. Thus, quote, we hold that the ratio laid down in Swami Shraddhananda that a special category of sentence instead of death can be substituted by the punishment of imprisonment for life or for a term exceeding 14 years and put that category beyond application of remission is well founded and we answer the said question in the affirmative. Unquote. Thus, taking into account the fact that in the case in hand, on one hand, a hapless 8-year-old girl child, who is none other than the daughter of the appellant's cousin sister, raped and murdered, and that too in an extremely brutal manner, revealed from the evidence on the record. We are of the view that course adopted in the decision in Swami Shraddhanand case and reiterated in Sri Haran's case has to be adopted in this case. In other words, even while commuting capital punishment, the appellant has to be awarded life imprisonment without application of the provisions of the premature release or remission for a substantial length of period. On such consideration, we are of the view that it would be just and proper to award punishment of imprisonment for life to the appellant for the offense punishable under section 302 by providing for an actual imprisonment for a period of 30 years without application of the provisions of premature release or remission. So, in this way, the appeal filed by the appellant accused were partly allowed and the sentence of capital punishment was commuted to the life imprisonment. This is all about the case note that we've had today. And for with yet another case note, we'll meet again. Namaskar.